With that, I will call the first case on this morning's docket from Wyandotte County, case number 126956, Carolyn Kemper as personal representative of the estate of David Kemper, appellee cross appellant, versus BNSF Railway Company, appellant cross appellee. Would the parties please state their appearances?
May it please the court, David R. Cooper and Andrew Reitman for defendant appellant BNSF.
Good morning, Your Honor.
Good morning.
Please the court. Good morning, Your Honor. I'm Lanny Vickery. I'm here on behalf of Carolyn Kemper, along with my co-counsel, Kaylee Hoffman.
Thank you. This case is scheduled for 20 minutes of argument per side, and there is also a cross appeal. Would you like to reserve any time on the cross appeal during oral argument, or do you want to just rest on your brief for that?
I think that can just rest on the brief. That is clearly a preservation point, as I think the court can understand.
All right. Thank you very much. And would the appellant like any time for rebuttal?
I'm going to reserve 5 times or 5 minutes and hopefully have it when I get there.
All right. 5 minutes are granted. And with that, Mr. Cooper, you may begin.
For purposes of background, this is a mesothelioma case. Also, it's a FELA case, which is the Federal Employers Liability Act, a federal act providing compensation for railroad workers injured on the job. A unique requirement of FELA compared to workers' compensation claims. A FELA claim requires that the plaintiff prove negligence, at least in the slightest degree, on the part of the railroad that caused the injury at issue. Here, Mr. Kemper served in the United States Navy, serving on a destroyer during the Vietnam era. And after coming back from his service in Vietnam, David Kemper worked for the Rock Island Railroad, which eventually went bankrupt, and later worked until 2006 for BNSF. In 2021, this lawsuit was filed after Mr. Kemper had developed mesothelioma. The allegation that it was a result of, at least in part, his service on the BNSF Railroad. During the pendency of the case, Mr. Kemper died of his cancer, and plaintiff Carolyn Kemper was substituted as the party for the decedent, both individually for a wrongful death claim on her own behalf and for Mr. Kemper's conscious pain and suffering prior to his death. The case proceeded to a trial. Important to this case is prior to the case proceeding to trial, Mr. Kemper applied for and was awarded veterans disability benefits for his mesothelioma, for which he was awarded roughly $40,000 prior to his death. And he received $600,000 in change, $610,000 from the Rock Island Bankruptcy Trusts. So proceeding then to the issues on appeal, again, I'm having reserved 5 minutes for rebuttal. I want to begin by pointing out and drawing attention to the fact that the amounts in dispute, or excuse me, the amounts that are not in dispute have been paid. The $350,000, the balance between the $650,000 of the $1 million award for Mr. Kemper's conscious pain and suffering was paid, and the $57,200 that's undisputed pecuniary loss for Ms. Kemper has been paid, and that was paid coming on in September 23, more than a year and a half ago.
Counsel, were those paid into court, or were those paid directly?
Okay. Paid directly.
Okay.
By agreement, but it was by agreement to avoid the necessity of posting an appeal bond. BNSF presents 2 issues for review in this FELA claim. The first being that BNSF is entitled to a pro tanto credit, or that's a dollar for dollar credit for those who don't do Latin, or in common parlance, an offset for payments made to Mr. Kemper for this same indivisible injury. The second issue is the lack of evidence to support an award of pecuniary damages for Ms. Kemper's wrongful death, damages in excess of the $57,200 to which BNSF concedes. Proceeding with the first issue, the trial court erred when failing to allow BNSF the pro tanto credit or offset for payments made by third parties for Mr. Kemper's damages arising from his development of mesothelioma or cancer. The jury was instructed to determine, and it did determine, the total amount of David Kemper's damages arising from developing mesothelioma, and that award was $1 million.
Counsel, just to clarify that, so the jury did not find the damages that were attributable to BNSF's conduct?
They found the total amount of damages sustained by Mr. Kemper for developing mesothelioma. And because FELA is, it requires the slightest degree of fault. So if BNSF is a 0.5% at fault, it's responsible for seeing to it Mr. Kemper gets 100% of his damages. And that's precisely the issue here, because Mr. Kemper got 65% of that $1 million during his lifetime before the case proceeded to judgment. Of that, $608,000 and change from the asbestos manufacturer's bankruptcy trust, and $40,900 from the VA for developing mesothelioma. And plaintiff is not entitled to double recovery or a windfall under the FELA or any other law. And so BNSF is entitled to that pro tanto set-off or credit, or that set-off under both federal and state law. The standard of review for this claim, it's a question of law. And federal law, BNSF advances the argument that federal law governs BNSF's entitled to the set-off and the credit, but federal law and Kansas law get us to the same destination. So whether we apply federal law or Kansas law, we reach the same result.
Counsel, does that require any kind of a factual finding by a district court as to what those payments were made for, or does everyone agree what those payments were? It
is undisputed that those payments were for Mr. Kemper's development of mesothelioma.
Thank you.
Well, for context, the bankruptcy trustee payments are, by definition, you have to prove you have mesothelioma and developed it from. In order to recover from the bankruptcy trust, you have to be able to offer evidence that you developed it, at least in part, from one of the covered entities here, the Rock Island Railroad. Likewise, the VA benefits, there's a statute that says if you served on any of a number of lists of destroyers during a certain era, and you develop mesothelioma, by definition, you're 100% disabled and entitled to VA benefits on that basis.
So it's kind of a legal factual finding, if you will, that's a statutory finding.
In order to get the money, it has to have been from the same cause. Right. And it's probably an esoteric argument, but in terms of we've advanced in the briefs that the Hess and the Shuttle cases say that we need to apply federal law, and that arises from the federal common law and the application of joint several liability, FELA. But I also have to recognize that you're bound by Golden, which says Kansas law governs this issue. So, and that's why I think it's important to say it doesn't matter which you apply, you get to the same destination. Now, we need to discuss what this case isn't about, because the appellee's arguments are, and both in the district court below and in their brief, talks about this being prohibited by Section 55 of the FELA. Doesn't have anything to do with the set-off that we are discussing. Section 55 addresses first a prohibition on any contract rule or rule, regulation, or device, that's in quotes, that exempts the railroad from liability. BNSF is not here trying to say it's not liable. It is liable. The jury found as much. The second section of Section 55 expressly allows a set-off for any benefits or compensation paid to the injured employee by the railroad directly for the injury, or to the extent they contributed to the benefits, for instance, for railroad relief.
In drafting that section, wouldn't it have made sense if Congress anticipated the type of set-off that you're requesting, that they would have also included a set-off for any other payments that may have been received for those damages?
You're reading more into the text than would be there if you're saying, in order to be entitled to the set-off, Congress has to have provided for it. Rather, the federal common law and Kansas common law applies to and allow this specific sort of set-off. And that also
law also allows for a set-off for previous payments by the same entity. So why would Congress include that in the statute, but not include what you're discussing?
Well, here, with respect to Section 55, it expressly includes and anticipates that the railroad will get credit for benefits paid directly to the injured party and be able to reduce that from the total amount of damages awarded by the jury. What Section 55 is silent about what happens to benefits paid for the same injury by third parties. And federal cases, specifically the Shaw case and the Benson case that we cite, as well as a host of district court decisions, the Hess case from the Supreme Court of Ohio, and the Oaks case from the Supreme Court of Mississippi, all reach the same conclusion, which is federal law allows, and in fact, it is error for a district court or trial court to not allow a set-off. Why? Because it results in double recovery and a windfall to the plaintiff. And nothing in FILA, nothing in the Ayers case says a plaintiff is entitled to double recovery. What FILA does say is a jury is to decide the amount of damages, which happened here, that the railroad, if it's liable in the slightest degree, is responsible to make sure that the plaintiff gets 100 cents on the dollar minus the plaintiff's contribution to that loss. Here, there is no contribution by Mr. Kemper. And then we proceed from that point. All right, a jury determines that Mr. Kemper's damages were $1 million. He's received $650,000 of those dollars already. He needs $350,000 to be made whole according to the law and according to the jury's verdict.
Counsel, is there the flavor I'm getting from you in your argument is that there's a policy choice behind FILA to avoid requiring a plaintiff to prove causation and avoid getting into the weeds with contributory negligent apportionment of liability. Is that fair?
That's fair, and that's also a fair summary of the Ayers case itself, which is, again, Section 55. And the arguments, by the way, in the Ayers case were first, the railroad was arguing for the ability to have a jury reduce the damages awarded to the plaintiff based on third-party payments. And the Ayers court explicitly said, no, that's not going to happen. A jury is to decide what the whole ball of yarn is going to be, and then leave it to the railroad to bear its burden to track down third-party tortfeasors to seek either contribution or indemnity.
So I guess how is what you're asking not a violation of that public policy? Because you're essentially, we've got a policy choice for the railroad to bear all of the damages, regardless of their percentage of contribution to those damages. And then now you're asking to reduce that liability based on what the plaintiff did and taking the initiative to go out and find other sources to compensate for those damages.
Whether it's Hess, Oaks, or Ayers itself, if there is a settling third-party tortfeasor, there's a dollar-for-dollar credit, and that was recognized in Ayers. That happened in the Ayers case where third-party tortfeasors in the Ayers case settled out before the case went to trial, and the railroads were allowed to credit on that, and the Supreme Court noted that as just the normal course of events. To address your question, Judge Klein, it's not a violation of that policy because the policy is that the plaintiff gets 100 cents on the dollar, but no windfall, no double recovery. The fact that here we are dealing with recovery from third-party tortfeasors before the case goes to trial, which relieved the railroad of the necessity or the obligation or the burden of moving forward to prove their contribution and or whether our right to contribution or indemnity. And in this case, both of them would have been contribution, not indemnity.
Was there any evidence at trial that was presented of potential other causes or contributing causes to
Yes.
the mesothelioma?
Yeah, the plaintiff's experts both conceded that the exposure on the destroyer alone was sufficient to cause his mesothelioma and did, and that the exposure on the Rock Island Railroad also in and of itself was sufficient to cause Mr. Kemper's mesothelioma and more than likely did. And frankly, the finding is that the evidence was all three contributed and caused his cancer.
But the question presented to the jury was whether or not the railroad caused
Any degree.
to any degree. That was the only question. So the jury wasn't asked to apportion damages or to award damages based on any of the other contributing causes, correct?
And the fact that the third-party tortfeasors settled out before the case went to trial relieved BNSF the obligation of bearing that burden and proving the fault of the other parties. And in fact, you have to reconcile that with the Golden decision, where in there the trial court precluded the Burlington Northern at that time from presenting that evidence and comparing that fault. And the Golden court found it was a reversible error to not have that fault determined by the jury in the first instance under the Kansas One Action.
Counsel, we've been focusing a lot on this first issue, which is understandable, but I do want to make sure that we have some time to talk about the pecuniary damages.
Thank you. I'd like let me roll over to that. With respect to that issue, the trial court also erred when entering judgment on a verdict for pecuniary damages that lacks an evidentiary basis.
Do you agree, counsel, that in defining pecuniary damages, we look to Kansas law?
As to what pecuniary loss is?
Yes.
No, you go to what it is still defined by federal law.
Well, I ask because in your brief, you cite a bunch of Kansas cases.
I do, and because Kansas cases also reached the same conclusion, sort of.
Well, so you can understand my quandary as to which of these do we apply?
You have to apply federal law, and that is the crux of our argument with respect to the pecuniary loss. Vreeland. I know it's a 1913 case, but Madison versus Marbury is an older case than that, and it's still good law too. And Vreeland explicitly says an award of pecuniary damages that are premised on the not common knowledge of the jurors is not supported. And
what level of specificity then is necessary? If, for example, if the testimony is that that Mr. Kemper mowed the lawn once a week, does that mean that you have to figure out, okay, so the present value of mowing the lawn right now is $30, and you do that once a week and you multiply that? Is that the level of specificity we're talking about?
Well, there has to be some basis to plug that into a calculator to figure it out. Yes. And that's why we're conceding the $57,200 is because there's evidence that he earned $100 a week at a car wash. And if you just assume that he would have done that for his, again, stipulated 11-year life expectancy, $100 a week, $52 or $5,200 a year times 11 years is 57 too. And frequently these cases are, this evidence is offered through an economist or some other expert, and it's undisputed. Nobody contests the fact that the only pecuniary value or evidence that was offered during the trial was that $100 a week at a car wash. While folks did talk about the care that he rendered to his wife while she had cancer and was otherwise injured in the home, Vreeland unequivocally says the jurors' common knowledge as to the value of those services is not sufficient to support a verdict and is reversible error.
Is it the value of those services, or it was the problem in Vreeland that it was so vague? It was common knowledge as to counsel and advice that people that a person would give. I mean, that seems very broad, right? Like, what kind of help in terms of counsel and advice, instead of, look, he did all of these things for me, and now I'm going to have someone else do that.
But the law is clear, and that's why I cite the Kansas cases about that, is the jury doesn't get to speculate as to what that value is. There's no testimony about the amount of time spent doing those things. There's no testimony or evidence and no exhibit that assigns a value to any of those things. And by definition, that leaves a jury to speculate what the total value of that is. And a verdict that is derived from speculation can't stand. So in conclusion then, the BNSF asked that this court find that the trial court erred by denying BNSF a pro tanto credit or set off against the payments already made to Mr. Kemper for his mesothelioma, and entering judges for pecuniary damages that lacked an evidentiary basis. We ask that you vacate the judgment in part and remand to allow the offset or the $649,489.73 for payments already made, and to reduce the judgment for pecuniary loss to $57,200.
Counsel, welcome. You have 20 minutes plus some. So.
I greatly appreciate it, and I hope I won't need it, but we will find out, as typically is the case. I'd like to start out with something that I want to make sure we're clear on this. The FELA is a federal remedy. It's not a Kansas remedy. Now, FELA cases can be brought in state court, of course, and state procedural rules apply. The substantive law is completely federal. And I wanted to get that out first because I don't want there to be any mistake about that. This is a federal law case. Point number one is purely a statutory construction case. And then, Judge Warner, as you point out, that you can't rely on the silence of Congress when Congress has specifically addressed a topic. In this case, Congress did expressly address the topic in Section 55. The title of Section 55 says set off. And the only provision in Section 55 is for amounts paid by the railroad. There were no amounts paid on the railroad. So with respect to the question of set off, federal law governs statutory construction, plain text. There is no right of set off, period.
Counsel, Section 55 deals just with the responsibilities of the defendant railroad in a FELA case. Do you agree?
Section 55 is basically a codification of the collateral source rule. And I'm not sure if that's answering your question.
So as I read it, there's a section that says that the defendant can't take some action to, contract away their liability, right? And then also the defendant is entitled to a set off for any amounts that it's already paid. Is there anything in Section 55 that deals with third parties?
No, Your Honor.
Does that mean that Congress didn't anticipate that there would be third parties in FELA cases? It seems like a huge gap that if we are to read into that omission meaning, that's a huge omission, isn't it?
It is, and I'm about to address that if I could. If in terms of a set off, the set off is controlled by 55. That tells you what you can set off. So in this case, you have these settlements from asbestos trusts. That's what we're talking about, and from the VA benefits. So how does it work? AIRS actually tells us. And what AIRS says at 165, 166 is under the FALA, an employee who suffers an injury caused in whole or in part by a railroad's negligence may recover his or her full damages from the railroad, regardless of whether the injury was also caused in part by the actions of a third party. Okay, we all agree on that. But then they go further. So what do you do when there's been a settling defendant? AIRS addresses that. Once an employer has been adjudged negligent with respect to a given injury, it accords with the FELA's overarching purpose to require the employer to bear the burden of identifying other responsible parties, and this is the key, and demonstrating that some of the costs of the injuries should be spread to them. Now, how are we going to do that? Contribution is not addressed by federal law. That's purely a matter of state law. And under state law, to prove contribution, you have to prove that the person who is supposed to be contributing, that their negligence was a substantial factor in the development of the disease, and that it proximately caused the disease. So it does appear at first, Judge Warner, that there's a gap. There's not. AIRS fills it. The gap is filled by the burden being on the railroad to prove its contribution case. It does not.
But contribution, as you indicated, is not, it's not a statutory matter. That means that we look to federal common law and state law to fill in that gap. And state law includes the notion that if someone has received other compensation for those injuries, it should be set off against the damages that are awarded.
If you can prove that it is an injury as to which the sum of the cost should be spread, the way that you do that, and let me make sure that we're clear, there is no right of contribution under federal law. This is purely going to be state law, okay? And under state law, then you can prove, of course, double recovery has been part of state law in certain instances, but if you're gonna prove under AIRS that some of the costs should be put back on the railroad, should be taken away from the railroad, then they have to prove that. They cannot prove that by producing a spreadsheet that has 30 settlements with amount with no proof as to exposure, no proof as to negligence, no proof as to substantial cause.
Practically speaking, how do you envision that the railroad would pursue contribution? Who would they go after? I mean, would it be the same people, same trusts that your plaintiff already recovered from?
It certainly could be.
And do those trusts allow recovery by the railroad? I mean, a lot of times those recovery trusts have limitations that are pretty significant on who can make claims.
Right. And if the railroad can prove that any particular defendant contributed to the injury, that they were a substantial factor, as we'd have to prove under state law, then in that case, you would get a credit against the settlement. And that could be.
Are you envisioning that your client would then just hold the funds until they go through that process to see if they're entitled to that credit?
No, Your Honor. I think the way that it works is once there is a determination that the railroad is liable, that it has been negligent, then the burden shifts to the railroad to prove that someone else, and it could be the people on the spreadsheet, could be other people as well, were a substantial contributing cause to the injury. That's a very different standard than the federal standard.
My question is, practically speaking, what do you do with the money that the same entities that the railroad would be pursuing have already paid? Do you just hold that in trust until that proceeding is complete? That's unclear. My expectation is that the money would not be paid until the court also went through, it couldn't be in the same jury, couldn't be to the FELA jury, but it could be a separate proceeding. And in fact, in footnote 23 of AIRS itself, the railroad submits that railroad requiring employers to sue for contribution will be wasteful, that it's going to be this process. And it is going to be a somewhat complex process. But in direct response to your question, what they should do is
does not hit the microphone. What we should do is the money, there would be some sort of proceeding within, it could be within the same proceeding. If not, well, it could happen in one of two ways. If it's in the same proceeding, that would happen probably before the distribution of the money, and you determine whether there's a credit. There could also be a separate proceeding, of course, to the railroad company, and that couldn't be against a settling defendant. That would be against a non-settling defendant to recover some of the costs. Is it unwieldy? It is a bit unwieldy, but that's the way that the system was set up because of the unique nature of FALA.
Does it matter here that the two payments that we are discussing are both payments that are triggered by causing mesothelioma?
To my understanding, and I believe by the record, it's not that you're talking about basically an administrative proceeding where all you have to show is that there was exposure, that there was that there was a provision of asbestos, and that there was a development of disease. There's no showing necessary of the kind of substantial but-for causation that you would have to prove to obtain contribution. That's what the railroad's burden is under Ayers. And so let me see.
Counsel, it appeared to me that the majority of courts that have struggled with this issue have come out the other way, have decided that a set-off is appropriate in these circumstances. Do you agree with that?
As stated, yes, but I think you have to look a little bit deeper. The majority of those cases involved a case where the settling credit was actually a defendant. It was named by the plaintiff. And because they were already a party to the lawsuit, like, for example, in the cases that he mentioned, the Shuttle case, and actually, while I'm on this, let me give you the quote from Kemper if I can find that easily, which I should be able to do. In the Palmer case, which is the Missouri Court of Appeals case, and it is a 311 Southwest 3rd 843. Three of these cases, Shuttle, Downer, and Benson, are immediately distinguishable from the case before us because the set-off sought by the railroad employers was in connection with settlement recoveries from defendants who were actually named parties in the employees' actions. So in most of those cases, you'll find that the defendant was actually named, so the plaintiff has effectively conceded that it's all going to the same injury. That's a very different situation than pulling in administrative settlements from the trust and certainly VA benefits, which are much further removed, with absolutely no proof of what you have to prove under Ayers to reach the point. That's how you get to contribution under Ayers. And there's absolutely no proof by BNSF that there was any sort of substantial factor by any of these people as to whom they sought a credit. No finding of proximate cause, no finding of negligence. It's just purely an award and administrative proceeding that looks at, was there asbestos there? Did you get a disease? That's all.
But how do you distinguish a case like Oaks in Missouri, where it was very similar? I mean, it was a FILA case where we have non-party asbestos trusts that then were entitled to that. Then the railroad ended up entitled. The Supreme Court found that the railroad was entitled to set-offs.
In Missouri?
Mississippi. Sorry, Supreme Court.
In Mississippi. The interesting, that's the Oakley case. The interesting thing about the Oakley case is there's absolutely no mention of Section 55. No mention of Section 55 at all. The same thing in Shuttle, no mention of Section 55. And Judge Warner, that's why I was struggling a little bit to give you a direct answer to your question. The cases have not been very consistent in terms of how they have addressed this situation. I think the concurring opinion in Hess, which was then discussed in the Missouri case and the Palmer case, tells you the way that it's supposed to be done under Ayers and under Section 55.
How do you answer the double recovery argument? Is there a way to differentiate the damages in the pools of money that your client recovered?
There may be, but I can't give you a better answer than Chief Justice Moyer did in Hess. I'm sympathetic to the railroad's argument that denial of the set-off representing settlement amounts received by an FELA claimant could result in the claimant receiving sums exceeding the amount of damages a jury finds was sustained. However, the United States Congress and the United States Supreme Court have settled that issue. That goes back to the original point. This is a matter of federal law. Will there sometimes be a recovery in excess of what's found by the jury? Quite possibly.
But there's no caps in FELA. We're not looking at, limitations on damage recovery in FELA. So we can't differentiate and say, well, you can only recover these types of damages under FELA, but you can recover other types of damages and in different claims. We don't have that kind of a piecemeal approach available to us here. Is that correct?
It depends. In the wrongful death context, for sure, because as we know from the cross point, which I said I wasn't going to argue, the Supreme Court in Vreeland in 1913 interpreted damages to mean pecuniary damages. So it doesn't include loss of society. Whereas in most wrongful death cases, you would have loss of society as part of it. That's the only one that comes to mind that would directly respond to your question. And while I'm on that, let me jump on the field to the second point. I think that the court understands this, but the problem in Vreeland, it was expansive, it was unclear in terms of how the instructions were phrased. But the problem with the instructions as given in Vreeland weren't that you can use your experience to put a value on something. The problem in Vreeland was that the instructions indicated that you could potentially, that the jury could have awarded damages based on loss of society. It was the care and comfort, care and society that was the problem. It wasn't that you can use your experience to put a value on it. In the case here, of course, as long as the standard under federal law is correctly given, the states have some latitude in terms of how they're going to formulate jury instructions. And in this case, the Kansas pattern jury charges were used. They expressly said you can award things you can put a value of money on. You cannot award anything for loss of society, because that's, as Vreeland interpreted the wrongful death provision of FELA, you can't recover those damages. Should you be able to, given the way that the conception of damages has gone forward in pecuniary damages? We think so. Do I expect that you're going to overrule the Supreme Court's opinion in Vreeland? No, not today.
Counsel, I'd like to talk a little bit about the level of specificity that is necessary to prove pecuniary damages. Certainly, the jury instruction that you pointed to said that you can award damages for anything that you can put a value to, but doesn't the plaintiff still have an obligation to explain to the jury what that value is and how we come about finding it?
I believe that, and I think that the Wendling case, which is a Kansas case, gives us some good insight into that. What we're talking about is the nature and extent. Now, there was not testimony in this case that because he mowed the lawn, because he trimmed the limbs, because he did the cooking, because he did all these things when his wife had cancer, that those things had X value. I don't believe that level of specificity is required. I believe that as to pecuniary damages, it does not conflict with Vreeland, and it's consistent with Wendling. You have to show the nature and extent, and there is evidence. There's sufficient evidence of the nature and extent of what these people's relationships, what this man did for his wife was in there. And he undisputedly had a lifespan of 11 more years that he didn't get to fulfill because of the mesothelioma.
In that instance, when we don't have discussion in the testimony about the amounts or anything like placing an actual number value on these services that were provided, how is that different from, or how can we be sure that the jury is not giving consortium damages? Like how are we sure that that this is not just kind of general loss of care and society damage. That is non-pecuniary damages, wearing pecuniary damage clothing.
I think that we have to assume that the jury followed the instructions that were given to them. Now, and I do want to clarify this point because Vreeland itself says that care damages are not necessarily non-pecuniary as long as they're tied to a loss of services as opposed to being tied to a loss of society. In this case, the jury was specifically instructed according to the Kansas charges, the pattern jury charges. No one has said that those don't accurately implement the federal standards, right? That's all given. They were agreed instructions, and we have to assume that the jury followed the instructions. But even if there is some pecuniary loss for care, it's not necessarily non-pecuniary just because it's care. And now, do we have to calculate a specific amount? No. Nature and extent testimony gets you there. We assume that the jury followed the pattern jury charges, followed the instructions they were given, and there's sufficient evidence under the standard to affirm the pecuniary damages. Yeah, and just as a final note, returning to point one, the real key on this, because I'll tell you, when you look at the plaintiff went and got these administrative remedies, right? They did get some recovery. That's undisputed. But the key point here is that just producing a spreadsheet of those recoveries, a bulk credit, does not discharge the defendant's burden under heirs, which would be to prove contribution under state law, which is substantial factor causation, proximate causation. If there's no other questions for the court, I'm going to sit down.
Any other questions? All right, thank you, counsel.
Thank you, Your Honor.
Mr. Cooper, you have 5 minutes.
I want to start where we ended just there, which is plaintiff's experts during the trial conceded causation of the destroyer asbestos exposure and the Rock Island Railroad asbestos exposure. So to the extent there's any argument about BNSF meaning its burden of proof, it's an uncontested fact. Those things caused the mesothelioma. It's also an uncontested fact. Those payments were made for that mesothelioma.
Counsel, has a fact finder, so that evidence was provided and perhaps undisputed, but has a fact finder ever made that finding?
That's why we have to go back for the additional hearing regarding the set-offs. But again, because of the undisputed fact, it's an undisputed fact, and you can use an undisputed fact for any purpose in the litigation. And here, that's the factual predicate necessary to entitle BNSF to those set-offs. I'm going to be all over the place. I'm sorry. First off, Section 55 is not mentioned in Hess and Oates because Section 55 is a smokescreen to the whole issue. Set-off is a separate issue. Contribution is a separate issue. And in fact, that's addressed explicitly in the Ayers decision, where the Supreme Court held that a jury could not apportion the fault to reduce the railroad's liability under FELA, which is what was being asked for by Norfolk in that case. But the Ayers court expressly held that a railroad can seek contribution from third-party tortfeasors. What's necessary? Had the payments not been made, had the liability not been established through the proceedings and granted through the efforts of the plaintiff prior to this case proceeding to trial, had that not been the case, then it would have been the burden of BNSF to put on evidence at trial and to prove the their contribution to this case. And that's where most of these cases where we're talking about and Galden's seem to have a little bit of rub, because Kansas's one action rule is a very important rule in Kansas. And Galden holds explicitly that it was error to not let the jury decide the comparative fault of a third-party tortfeasor in that case. So when those things are still hanging fire by the time we get to trial, then it's going to be an issue for the jury to decide. Here, it was not an issue for the jury to decide because the payments had already been made and the basis for those payments is not in dispute. What plaintiff is suggesting here would allow a plaintiff to circumvent and deprive the railroad of its recourse or recovery from those third parties. In other words, just go settle with them early and the railroad gets stuck and there's a windfall. And that's clearly not the law in Kansas. And that's absolutely contrary to Kansas law, both Gold and York hold.
Counsel, I know you have a lot that you'd like to talk about, but what are the, what do you think should happen here? Like what procedurally, if you prevailed, and what would be the next step that would happen?
I read that, and I really meant that. Based on this record, BNSF has already established its right to a set-off. And so what should happen here is a remand with instructions to the trial court to allow the set-offs for those $650,000 round and to reduce the judgment for pecuniary loss to the $57,200. There's nothing else to do beyond that because the plaintiff doesn't dispute that there's no other evidence of economic value, and that's one of the other parts. And by the way, what we're talking about here are pre-suit settlements. And when there's a pre-suit settlement and that party is dismissed from the case, here they were never added to the case, but in Golden, the party was dismissed from the case.
But
they're dismissed and their liability is not adjudicated either.
But Mr. Cooper, I'm sorry, but procedurally, say that was the court's ruling, but on remand, aren't there in the instructions, aren't there findings that the district court would need to make before the set-offs were permitted?
No, that they could make. Let me think that through. The factual predicate is there, so I don't believe there are any findings the court has to make because it is undisputed. Those monies were paid. The basis for those payments is undisputed as well. And based on those undisputed findings, BNSF is entitled to the set-off in those amounts. Whether you say that remanded for the court to make those findings are the only findings left to be made.
Why wouldn't you need any evidence presented to apportion liability amongst the contributors?
Because when it comes to settling third-party defendants, it's dollar for dollar credit, and it doesn't matter what they're because federal law, and here's where federal substantive law does matter. The liability is joint and several, and we get a dollar for dollar credit for any, and if that results in BNSF paying less than 100 cents on the dollar, as long as the plaintiff is made whole, it is on the railroad on these facts to make up the difference between what plaintiff has already received and the $1 million the jury awarded.
I understand the policy choice and not making the plaintiff carry the burden to apportion liability amongst the parties, but why wouldn't it be appropriate to still place that burden on the defendant?
The law does. Here, the issue is the plaintiff met that burden for us before we got to trial. So there's again, had that liability been hanging fire, had that liability been contested, it would have been BNSF's burden to haul those people into the courtroom and have them on the verdict form.
Counsel, I have been, let's just say, generous with your rebuttal time, but are there other questions from the panel? And then I'll give you 15 seconds to wrap up.
I just want to draw your attention to, it's page 35 of my opening brief with respect to the cases under the Death on the High Seas Act and the Jones Act. Those are the more recent cases applying FELA standards, telling you the level of proof necessary to meet pecuniary loss.
Thank you, counsel. Thank you, everyone, for your very interesting written and oral arguments in this case. The court takes the matter under advisement.